We will resume now the afternoon session. Mr. Barnes.
Thank you. My lady and my lords, at the end of the morning session, I put forward the proposal that the southeastern boundary of the triangular area might have been the whole hedge lying between the triangular area and the sommet. And as Lord Briggs pointed out to me, really what established where the bottom right-hand corner of the triangle occurred would have been the presence of the hedge that was said to mark the boundary between the remainder of the driveway and the triangular area. But there is a bit of information that occurs in the subsequent conveyance of La Roche-Dou, which suggests that my theory may be the correct one. If we go now to the 2009 conveyance, where it's describing on page 488 the item 1.6.2, which is the driveway, what it says is the boundary is to the northeast by the field belonging to the Brayo heirs. So that boundary. Southeast for a short distance, which is this bit where the nib has been cut off. And northeast by land with a dwelling house known as Le Sommet, belonging to Mrs. Claverdetcher. The hedge forms the boundary and belongs with the property. And then the next boundary is the southeast by Rue de Rougeval. So what has been described as one continuous boundary in the 2009 conveyance is this line taken from the bit where the nib has disappeared all the way down to the road. Now, if there was the triangular area was smaller, then this boundary description would have given us we wouldn't have had Le Sommet being to the northeast all the way down. There would have been a boundary giving us Le Sommet to the southeast for a short distance. It's because it's given us one continuous boundary that enables me to suggest that the triangular area did in fact occupy approximately the whole of this area. And one other thing that might assist in determining this issue is by looking at the photographs that were taken in 2009 or late 2008 when the appellants carried out conveyance. And the relevant photograph seems to me at 553 of photograph number 5. So this is photograph number 5, shows us the beginning of the driveway, or not, a little way along the driveway, with the sommet to the right. Five, and the photograph number 6 below that is taken further up the lane, but this is towards the bottom of the lane where the driveway adjoins the triangular area, and you can see it's a straight line all the way up. And it's not very good evidence, but it's the best we've got. That looks like a hedge on the right of photograph 5. I've got one more observation from the 2009 conveyance. So that's going back to page 488. I'm referring once more to the plan. I'll hold up one that I haven't marked. And this one's 2842, but it makes no difference. The boundary, the western boundary, as described in the 2009 conveyance.
That's better. I'm sorry. You're holding it way off the side of the picture, and it's impossible to see.
Yes. I'm trying to get my orientation right. The western boundary is described at paragraph 5.4 of the 2009 conveyance as the southwest, the west, the northwest, and the southwest by land with a dwelling house known as Rougeville, otherwise Late Revel, belonging to Mr. and Miss Harding, boundary marks between. So that's the southwest, the west, just here, the northwest, here, and again the southwest. What that boundary description has given us is not a straight line which the boundary marks, as said by the appellants to have been established, but by exactly what is shown on the plan. So in the 2009 conveyance, they've described the western boundary as being as it's shown on these plans, and not a straight continuous line going from the road more or less to where the Rushdu proper starts.
So what you're saying, as I understand it, if you start at the bottom, southwest, that would be further down the road. Then as you get to the dog leg, the first element of the dog leg, it would be west. Then,
yes.
Then northwest, then southwest when you get up further up beside the field, the Bidwell field.
That's right.
I see. Yes. So if it was relatively straight, you wouldn't need all those different compass points.
No.
Thank you.
And that pretty much completes my submissions.
I wonder if you could comment on Guernsey practice about conveyancers going out onto the site to look at Bourne. Mr. Furbrash made some representations about that, and I wonder if you could either confirm or qualify the picture that was given.
Right. Well, in the old days, conveyancers tended not to go out as frequently as they do these days. For practical reasons. But the normal practice is to get the title, try and work out what you're expecting to find on site, and then go and have a look and see whether it matches up. So it's very much a process of being on site in Guernsey. There's no doubt about that. When it comes to finding a boundary which is described as boundary marks between, boundary marks between is a common description where land is being split up, and the either there may or may not be a plan, but frequently you will see the parties describe the boundaries being boundary marks between, and there might be some provision for establishing a more permanent boundary in the future. But boundary marks between doesn't tell you a great deal, because you don't know what's being used for the boundary marks. And although it may seem heretical to say it, I know that when the conveyancer refers to boundary marks between, there may not be anything there at all. And what they're doing is just repeating a title so that they can't be criticised for having tried to convey something that didn't exist, that wasn't there, for giving someone more land than they were entitled to. They stick to the previous boundary descriptions, and then that is a safer way of protecting yourself from liability. So but in summary, it is very much a physical process of carrying out an inspection before you execute your conveyance.
It's a fair inference.
Yeah.
It's a fair inference, isn't it, Mr. Barnes, that the draftsman of the 2009 conveyance didn't do a site visit?
Well, we know they did, because
How could he consciously and with a desire to assist his client have described the western side of the boundary as being southwest, west, northwest and southwest, when we know that since about 1968 at the latest, it was in a much straighter line?
Well, because the answer to that is the conveyancer was conveying what Mrs. Harrison had title to, rather than what was on site. I'm missing what I'm.
Forgive me. it's a fair guess he would have used boundary marks between in this case, having looked at the French version of the same expression in 1960.
Yes, this was an example of someone applying precisely the same boundary description, only there's a contrast with 1960, because in 1960, the conveyancer would have said that he was conveying everything to the east of Lake Revel. Without going into detail, in 1960, he gave it. He just said it was to the east, and that was sufficient. When the conveyancer came along in 1968, that conveyancing clerk approached it with more detail and gave us, I think, 3 or 4 different compass points to work through our boundary. But they weren't doing anything, they weren't conveying different land, they were just being a bit more thorough in their description. And that description came from plan.
Does it come to this then? This is really the point you've been making in relation to page 488, the fact that we have these various compass points. That means that the title conferred on Mr. and Mrs. Lovering, the description in 5.4 isn't in any sense at loggerheads with the description in the map itself.
No, it's entirely
consistent. So whatever the situation may have been in 1960 or 1968, when we look for the Loverings title, there is no conflict between the description and the map.
No, there isn't.
And I mean, if that is right, then 1960 and 1968 might be irrelevant. We just look at what Mrs. Harrison has given the Loverings.
In a way, yes. But in order to determine whether she owned it, we have to know what happened before in her title.
Yes, but I mean, if Mr. Fairbrass was right, looking at her title, she may, if you're right about 5.4 and the map being consistent with each other in 2009, then she might have conveyed less than she owned. Mr. Fairbrass is right. If you're right about the prior titles, then the 2009 reflects all she ever had.
Yes. Yeah.
But would the consequence be that on either basis, you say the Loverings didn't get title to pass on the road, that it actually exists?
The only boundary that was different was the one to the east, which was the driveway less the triangular area.
Yes, subject to that. Yes. Thank you very much. Is there anything else you'd like to add?
There was only one point. There was mention of the prescription not applying, and the reference to that, if the court needs it, is at page 82 of the judgment of the Royal Court, paragraph 10, where the Deputy Bailiff records that the appellants withdrew, or the respondents in that the trial withdrew their claim to prescription which they had pleaded in their defences.
Yes, I saw that, but is Mr. Fairbrass's presentation of the law correct, namely that in Guernsey, as in Scotland, to prescribe to a servitude, you need a title. In Guernsey, in Guernsey, prescribe to title to land, you don't need a title capable of governing that land, but you do need exclusive possession. And in this case, the road was also enjoyed by the Hardings and their predecessor.
That's it. That you can't acquire a right of way or any other right by prescription without a title. but you can, wait, in other words, you can't acquire a right of way without a title. But you can acquire land without a title unless there is a case pending before the Royal Court which is going to deal with that question, in fact.
But is the understanding at the moment that there would have to be exclusive possession of that which you were wishing to acquire ownership?
It is. And the question before the Royal Court is currently whether you need a title as well, or whether possession is sufficient. So,
well, that's very, very helpful indeed. I think you, at least on one matter, counsel on both sides are in agreement.
Yeah.
Is there anything else you'd like to add?
No, there isn't. Thank you.
Advocate Barnes, thank you very much indeed. Advocate Furbrash.
Right. There's a greater measure of agreement, my lady and lords, as might otherwise appear, because my friend properly conceded that it very much is a requirement, good practice to go on site to when you're doing a conveyance, and that's consistent with the authorities, because you have to apply the conveyance to what you see on site and take into account the topography. Also, it would be correct, my friend said, to state that if prior title states that the western boundary of what you acquire is boundary marks, then you should follow that title. You can't get any more or any less. Your western boundary is the boundary, are the boundary marks. And therefore, consistent with that, the route of title, the courts above and below have found, and there's been no issue between the parties, the route of title to what the western boundary as set out in the route of title as to what the Delamares and then through Una Harrison and then the Loverings acquired is boundary marks on the western side. And that's particularly important because it all ties in extremely well with what the observations of Lord Briggs. And Lord Briggs inquired, it appeared that there hadn't been a site visit. But in fact, if you look at 551, the photos which follow on 551 are the photographs taken on the 31st, on about 31st December 2008 of the conveyancer from AFR who went out on site, and he maintained a photographic record. And that was what amongst other evidence which the jurates took into account when determining the position of the board. And so if we agree that effectively and plans, the two plans the courts above and below held show that the same area of land was conveyed in 60 and 68. And as my friend says, effectively the plans are the same. And everything which was acquired in 60 was also conveyed in 68 because it's the same area. And it's quite correct to adopt approach which Lord Briggs said might be open to us. One of the questions put to my friend was, Lord Briggs, was Mrs. Harrison could have hedged off the triangle. Yes, my lord, I agree with that. So effectively, there was a part sold off and the hedge forms the boundary. But we do know also from title that to the west of that was some land which she retained. And that's accepted by the courts above and below, and there's no contest between the parties on that. So in between the hedge and the Bourne, Mrs. Harrison retained part of a driveway which she could convey to the Loverings. And the question is, what is the extent? And I say that you can get the extent of that land only by determining the position of the Bourne. And the Court of Appeal did not do that, but the Royal Court did. And it's useful if we look then therefore at page 451, which is the 1960 conveyance, because that tells you everything you need to know. I would respectfully submit. So on page 451, it says, when we're talking about the driveways, lisière de terre de 10 pieds ou environ, of 10 feet or thereabouts de length in width, indiqué en tien bleu sur le dit plan. So outlined in blue or shaded in blue on the plan annexed here too. Et gisant au nord-est, so that would be lying to the northeast, but we would say bounded on the southwest. If we were conveying in English, you would say bounded on the southwest and the west, and again on the southwest, ou environ, or thereabouts, d'une maison, serre de greenhouse, and also terrain, land belonging to Guil, but we know them all as the heirs Lalacha. Keywords, they born entre deux. Sorry, I apologize. I'm looking at the 68 conveyance there. Do apologize, looking at the wrong one. Page 439, members of the court. My error. I don't think it makes a difference. The best conveyance is the 1960. I do apologize. And here's where you see the point I think which Lord Briggs has made, and I think it's absolutely correct. It's at 439. Now, when describing the driveway, it says secondo, une lisière de terre, so it's a strip of land, brackets, tien en bleu, so I suppose shaded blue, avec mesurage sur le dit plan, with measurements on the plan. Okay, when you look at the plan, which you'll find at 429, you'll find that there are 3 measurements of 10 feet. So those are the measurements referred to. And I don't understand there to be any contest between the parties. If you measure the driveway on site by reference to these measurements on the plan, they're approximately 10 feet. So in other words, if you go to the plan and go to the blue area and look for the measurements as indicated on the plan at those points, they should be 10 feet. And that's what you see on site. And I'll take you to the photographs in a second to show that that's the case. What was seen in December 2008. Then materially, as again, Lord Briggs has pointed out, if you go over the page to 440, so what was the western boundary of what was conveyed in 1960? Because we know what was conveyed in 1960 and was followed through in title was conveyed to Una Harrison. And that's a gisant comprising allée, in other words, bounded on the west or thereabouts by the said house, greenhouse and land belonging to the vendors, i.e. the heirs Lalacha. Keywords, they born entre deux. So 2482 is the same as 4782, and you can't get the answer from the plan because what the plan shows is there should be a width to the driveway of approximately 10 feet on the point shown on the plan. And that corresponds with what you find on site. And I'll take you to the photographs to show that. So the plan doesn't give you the boundary. It's the words of description, des bornes entre deux, which is why as a conveyancer, as my friend correctly conceded, you would repeat des bornes entre deux through title, because that's the defining words of description. Now, that being the case, and my friend also made the concession that Mrs. Harrison probably would have planted a hedge along to demarcate off, and that makes good sense. And it's very much a conveyancer has to go out on site and apply the conveyances to the topography of the land. So if we look at, and my friend, I'm afraid, misinterpreted one of the photos. If you look at 551, members of the court, page 551, this photograph is with you standing, if you've got open 429, you're standing with your back on Rue de Rougeval, looking down the driveway, and on the left-hand side, the wire fence is the Hardings property. And bear in mind that Hardings assert no title to the driveway which is situate there. And that's where the jurists say that's where the boundary marks would have been placed, des bornes. Along in 1960, the heirs de Lasher conveyed off the area of land, and the boundary were the boundary marks. And then if you scroll down to the next photo, that's standing in the driveway with your back to the driveway looking out onto Rue de Rougeval. So now going on to 552, you can ignore the top photograph, because what the conveyancer was doing there was taking some pictures of manhole covers and things like that.
Mr. Perez, just to make sure you understand that you have in total 15 minutes, so use your time to cover the essential points that you want to cover. But I will hold you to that 15 minutes. You've now got you've got 5 left. Thank you.
Thank you. So then if you come down, the next photo, you're standing now with your back, looking back up to Rue de Rougeval. If you see, members of the court, the wire fence on the right, this is where my friend fell into error, I believe. The wire fence on the right is actually the Hardings property. On the left would be the hedge established by Mrs. Harrison. Do you see? And that's what we say, that's where the boundary marks would be. And it started to curve. Then if you look at 553, what's happening is you're now looking back up the driveway and you see it curves round to the right. On the left is the Harding property and it's the wire fence. On the right is the hedge which would have been established later on by Una Harrison. Then when you get to the next picture down at the bottom of 553, here's the curve again. On the right-hand side, and this is the one where my friend fell into error, on the right-hand side is the Hardings property. You can see the wire fence. On the left is the hedge which Una Harrison would have established. So what the jurists are saying is the logical place is we know if Una Harrison's property, what she sold off is on the left, and we've got some driveway, as you look at this photo, to the right, are you going to place those boundary marks somewhere down the middle of that driveway? Or would you place it by the wire fence, which is where the Hardings are? And the Hardings acquired their title from the heirs de Lasher, and following their title back in the 1960 events, it's boundary marks. Okay, it makes no sense. And then again, if you go to 554, again, on the left-hand side, you see the Hardings property, and on the right, the hedge. And you can see the curve. And that's what a conveyancer would see. And the jurists took that into account. So if in the right is the bit that Mrs. Harrison sold off with the established hedge, you've got to come to the west, i.e. the left of the photograph, and decide where to place des bornes. So for the Lovering's case, to get off the ground, you would have had to have placed boundary marks intersecting the driveway, as shown on 17B, with and again look at the judgment of the Royal Court, common ground, typically granite sets, intersecting this driveway in 2 points and forcing somebody to go over land 5 feet high. And then when she's sold off, you've got the same point, but there's the hedge on the right and the Hardings on the left, who don't assert any title to this property. So was it really illogical for the jurists to say that we would place it there? And one final one, if you look at 555, you're standing with your back to La Roche d'Ouve, looking back up the driveway. So you start to see the curve much more clearly. So when you look at the photographs and what a conveyancer can see on site, and what he's looking for is a hedge, which is most likely established by Una Harrison, and also where would the boundary marks be placed? Where's the logical place to put them? Well, do the Hardings claim anything to the east of that well-established hedge and fence? The answer's no. So why would you place boundary marks anywhere other than along that boundary? And that's exactly what the judge said. So if when you retire members of the court, if you look at the photographs, what the judge took into account, remembering always the wire fence is the Hardings. They don't assert any title to this driveway at all. And you can see the curve on site. That's what a conveyancer would see. And what my friend is effectively asking you to do on behalf of the appellants is to say to place those boundary marks intersecting the driveway in 2 positions. And there's no reason to do that. The jurists went out as well on site, having regard to the topography, having regard to the photographs, and said, well, the logical place to put these boundary marks is along the edge of the neighbouring property, which does not assert any title to the driveway.
I think we have that point. You've made it several times. Is there anything else you wish to?
My submissions.
There's your submissions. Well, it only remains for me to thank counsel very much for cooperating with us in enabling this appeal to be heard in what are not the easiest of circumstances. I hope you feel that you've managed to get your points across despite the distance between us. But I'm very grateful to you both and to those who have helped you preparing this appeal. And I quite understand why the important volume 2 wasn't with us. That was caused by the lockdown. So
Yes.
Thank you all very much. The board will take away this matter, consider what we should humbly advise. Thank you.
My lady and my lord, I'm simply obliged to you and obliged to my friend as well.
Thank you.